Добрый день, уважаемые коллеги. Мы рады приветствовать вас на нашем семинаре.
Okay, so I would like to present our academic director, head Department of History of State and Law of the Kutov and Moscow State University, distinguished lawyer of the Russian Federation, Doctor of Legal Letters, and Professor Igor Isaev. So I would like to translate his speech. First of all, so he said, "It is indeed a pleasure to welcome you to the second International Scientific-Methodological Seminar."
Тема семинара не является традиционной в нашей современной науке. Дело в том, что нормативистски ориентированная юриспруденция, она совершенно определенно стремится отождествить себя с рациональностью.
So today our theme, Methodological of Law, Irrational in Law, is not traditional. The reason of this theme was because of normativism. Every time wants to go to rationality.
Естественным продолжением этого является превалирование цифрового и техницистского подхода.
So we right now see the technological and digital research.
Такие понятия, как магия, миф, утопия, оказались в сфере филологии, культурологии, этнографии, и очень мало места занимают в юриспруденции.
We should say that that categories as mythology, as извините, пожалуйста, Игорь Андреевич, мифология, религия.
Сферы, филология, этнография.
So mythology, mystic, magic are now only in philosophy, philology, culturology, but not in jurisprudence.
Вместе с тем, огромное поле в правовой мысли, в правовой традиции, в правовой реальности занимает область иррационального.
But we should say that a great field in jurisprudence belong to irrational.
Рассматривается такая линия развития, если можно так говорить, от мифа к магическим техникам управления, от магических техник управления к категории суверенитета и далее на совершенно модерную категорию биовластия.
From the myth we go to a magic, from the magic we go to
В этом направлении уже идут исследования.
So we have many researchers in this field, but
есть монографии и диссертации.
We have books and researchers in this field, scientific field.
Поэтому задача нашего семинара, я вижу, в том, чтобы не только популяризировать эти темы.
So the task of our seminar is not only to populate these rational themes, but
выслушать специалистов, лиц, заинтересованных в этой тематике, о тех подходах, которые они разрабатывают.
But also to hear the researchers and experts of this point of view and want to know what they're looking forward in their research field.
Направления, которые предложены на семинаре, имеют самый широкий спектр.
So our scope have a very huge and large field.
Я думаю, что коллеги, которые будут выступать, которые будут дискутировать в этом семинаре,
I think that our friends, our colleagues that will be in discussion
предложат свои новые взгляды, и эта дискуссия
they would like to give us a new point of view, and this discussion
даст всем участникам такое творческое удовлетворение. Они что-то дадут, они что-то получат.
So, and we should then, because of their new view for jurisprudence, we should have a very interesting and creative, opinion and sign.
Мы с большой заинтересованностью ждем ваших выступлений и желаем вам вот этого творческого удовлетворения и успеха в этом семинаре.
We are looking for you with a great pleasure for your interest, research interest. We think so that on behalf of all who work so delighted to be with us, we extend sincere welcome to each of you.
И я с удовольствием передаю руководство нашим модераторам, господину Сигалербо и госпоже Румянцевой. Удачи вам в этом семинаре и в работе.
So I wish you good luck. Thank you for all of you, and I'm pleased to give the speech for our moderation for Mr. Sigalebra. So good luck for everybody. And we wish you a good luck for your discussion, creative discussion. So please, dear Gianluigi, can you tell us a few words?
Well, I thank you very much for the invitation and for. Can you hear me? Because I had some problems and I
yes,
could not. Can you hear me well? Thank you. Well, I thank you very much for your gentle invitation, and well, I am very curious, to hear all the contributions, and well, I think I do not know if in this moment whether I should speak for the first one or how it is the order of the contribution. But anyway, I would like to thank you really very, very much for inviting me, for the interest you have given to my presentation, to my project. Thank you.
Джан-Луиджи благодарит за его приглашение на сегодняшнее мероприятие. Вот. И он сейчас еще раздумывает в свете своей темы конкретно, о чем он будет говорить. Thank you, Gianluigi. Okay, so as moderator also, I believe that everything will be okay. We'll wait for you also on Friday, December 4th, and wish all of us good luck and good discussion, creative discussion. This is a very interesting item, and I would like to see all of you on Friday. I believe you will find us very interesting. It is the first session, and so it's only the beginning. And I would like to give the first word for our first speaker. He's our great friend, Mr. Giri Ananta Kumar, so Professor Giri, and his item is the future of law, drachma, responsibility, and alternative planetary futures.
Thank you so much. Thank you so much, Pasiba, dear Professor Valentina. Pasiba,
oh,
dear
I'm not yet professor, I'm associate professor.
Okay, so dear Dr. Valentina, dear Professor Igor, and dear Dr. Gianluigi, my dear and respected friends, and Pasiba, thank you to all participants co-present in our dialogue today. Very interesting theme, the mythology of law. As Professor Igor has already challenged us, that when we think of law, most of the time we are within the realm of the rational. And therefore, he challenged us to think that the themes like the mystic and the mythological are not cultivated at the heart of the vision and practice of law. I wish to build on this challenge and then relate to the challenge of irrational, the theme, the irrational in law. And when we think of irrational and rational, of course, we look at Kant, Immanuel Kant on the one hand, and Friedrich Nietzsche on the other. And in between, from the Russian tradition, the great literary tradition, when we read Dostoevsky, for example, Crime and Punishment, and then Brother Kamaradzov, you know. So in all these work, for example, in Dostoevsky, Crime and Punishment, there is the irrational, rational, but also a kind of love at work. And Raskolnikov, for example, the love that he has, you know. So I would like to bring the theme of law, but thinking about the legal discourse, and it is very important to pluralize, to open up our idea and vision of law, and how the thought and practice of law is multidimensional. It has simultaneously rational, irrational, but also the element of love. And also the element, another element that we must think about, along with the mystical, is the supra-rational. And therefore, in a way, if law in the modern world has been bound by individualism on the one hand, and rationality on the other, and nation state, so today the future of law depends upon an acknowledgement of our binding in these three fields, individualism, rationality, and nation state, and then move towards transformations. For example, from individual, simultaneously individual and community. And this community is not just the native community, this is the interacting community of the global and the cosmic. Similarly, rational and irrational and also supra-rational and also spiritual, they interact together. So in fact, when we look at discourse on law, for example, Paul Ricoeur or even Jacques Derrida, the great philosopher, we find that how it is impossible to do justice, because any project of justice is already limited by the framework that we have. So that impossibility of possibility, it requires transcendence, both immanent. For example, another great contemporary legal philosopher and thinker, Jürgen Habermas, in his work on law, Between Fact and Norms, he is challenging us to look at law as part of our immanent, you know, how our immanent practice, our discourse ethics, we argue with each other. So that immanence is important, but at the same time, there is transcendence. And this transcendence is not just immanent transcendence. For example, we are not just bound by the immanent legal order or social order or positivist law, but we are also at the same time transcending it. So human beings are both immanent and transcendent. So we need to rethink our concept of human. We need to rethink our concept of society. And that transcendence is constituted by many aspects. For example, as we are human beings, like, you know, maybe you are able to look at my face and I can see the face of Valentina. Now, the great philosopher Emmanuel Levinas says that when we look at the face of the other, that is a moment of transcendence. And when we look at the face, but therefore in law, do we look at the face of the other? The usual picture of law is the woman where her eyes are blindfolded. And this blindfolding eye is the symbol of legal impartiality. And no wonder then, in John Rawls, the great thinker of law and justice, a theory of justice, How do we create a just society? By becoming blind. We are with our veil of ignorance. But that is one aspect of being just. Another aspect of being just is to keep our eyes open and look at the face of the other. Look at it, and maybe somebody has committed a crime, as in Dostoevsky's Crime and Punishment. But as Derrida would say, that the self that has committed the crime is not an eternal self, it is not a fixed self. Therefore, how do we practice law and justice when the self that has committed a crime or the subject of law is not a fixed subject? At the same time, of course, we would have to practice law, bring a sense of order and justice. So therefore, the mystical element is quite central. And I am also here remembering another great contemporary critical legal philosopher. He's Roberto M. Unger, originally from Brazil, and having taught at Harvard for 50 years. And his reflection on law also bring these multiple ideas together. For example, he's challenging that society has two kinds of sacred. One is a social sacred. For example, in Russia, now Russia has a system of law, India has a system of law. But today, with the kind of fragility of life that we have, the national law is not paramount. That if we look at that, the national law is sovereign, as Hannah Arendt would say, how do we recognize the very fact of being born? No matter where we are born, and not only human beings, but also non-human beings. Law is so far in modern law has been anthropocentric. It has been limited to only human beings. Our ideas of justice are anthropocentric. But do we think of justice for dogs, for example? Do we think of justice for non-human animals? As Derrida would say, that what is important that for human beings, not that we think, but the question is, can we cry? Can we weep? Can we feel the suffering of others? And when it comes to suffering, then suffering is a condition of life. It is not limited to human beings, and it is not limited only to legal citizens of a nation state. So therefore, this invitation today is an invitation to rethink law in many ways. And when we think of future of law, we also need to think of future of law in the context of the present, the condition of the present where we are. And we know the fragility and the unsustainability of the present in many ways. The legal present, the political present, what Michael Foucault, another great thinker, called the ontology of the present. Now, the ontology of the present is already plural. There is not only one ontology. If we look at law, for example, there is plural laws. But at the same time, there is predominance of Euro-American law in the global legal discourse. Now, we need to pluralize that. We need to create ontologies, not only one dominant ontology and epistemology. So in order to move to future of law, we need to think about our ontologies of the present. And these ontologies are plural, and they are not just societal ontologies, there are also philosophical ontologies, philosophical ways of thinking and being. And therefore, we also need to look at our past, because our notion of the future is already shaped by our notion of the present and the past. So I would like to therefore bring a connected sense of time, past, present, and future of law builds upon a sense of connected temporality. It is not an isolated sense of futurism, which is not related to critical present and critical past. And therefore, we need a new archaeology. Therefore, the mythological is very significant in the sense that the mythic is not just a story of the past human condition. There is a mythic dimension in the present. The mythic, where the nature, human, divine, humans are communicating with each other. And that mythology, where all of us are vulnerable, we are not just perfect. And with that, I would like to bring here a paragraph of thought from a great thinker from India, and his name is Ashish Nandi. Ashish Nandi wrote an essay on, after Second World War, when there was, the trial for the war criminals, and many of the Nazi, the crime, criminals, they were tried in Nuremberg, and some of the Japanese were tried in Japan. And in that International Court of Justice, there was one judge from India. His name is Radha Vinod Pal. And Ashish Nandi, a contemporary writer and thinker from India, wrote an essay almost 25 years ago called The Other Within, the strange case of Radha Vinod Pal's judgment of culpability. And he writes, in the Indian epics, as in most pagan worldviews, no one is all perfect, not even the gods. Nor is anyone entirely evil. Everyone is both flawed and has redeeming features. Please note, therefore, when we are in law, we also have to talk of reconciliation, redemption, reconstitution, and recovery. And therefore, law is not just an instrument of crime and punishment and the institution of jail, that how do we create law also as a partner in a new hermeneutics, politics, and spirituality of reconstitution, restitution. For Radha Vinod Pal, the only dissenting judge of the International Tribunal judging the Japanese war crimes, the name of justice should not be allowed only for the prolongation of vindicative retaliation. So justice is not just vindicative retaliation. And you might note that there are profound new movements of justice today, where the work of justice is not just retribution or revenge or kind of punishment, but how do we create reparative justice? Also, the very deep concept of transitional justice that is also happening, for example, in the relationship between Japan and Korea, and also the whole restorative justice, how justice can heal. And here we can take the example of the Truth and Reconciliation Commission in South Africa, where it, to some extent, it was an elementary practice of reconciliation. With this, I would like to come to the whole question of love and dharma, and how integral love is to law. And that way, the future of law lies in integrating love, law, dharma, and dharma is a theme from the Indic tradition. I will explore it a little more, but dharma means right conduct. How do we think right way, right conduct and right thinking? And to some extent, it corresponds to the notion of the nomos in the Greek tradition, the nomos. And then also we bring responsibility. So my submission is that the future of law depends upon integrating these elements in creative ways, critical and creative ways. And therefore, and that kind of work is an alternative future, because future, when we talk of future, if future becomes a projection of the present that it is, then that future also would be a reproduction of the present. The great anthropologist Arjun Appadurai, who also has worked on law and anthropology, one of his books is called Future as a Cultural Fact. And I would like to say that when we look at future as a fact, now fact is also embedded with values. Therefore, future as a fact would not be different if the present fact is not interrogated. For example, the present fact of legal positivism, the present fact of anthropocentric law, the present fact of nation-state-centered legal positivism. So the whole challenge of alternative futures is that the work of the future is a creative work, it is a critical work, and alternative futures emerges from alternative understanding and realizations of the present and the past. And therefore, when we talk of mythology of law, therefore, the future of law, that future work depends on alternative memory work. And to give you an example of alternative memory work, I would like to give you some examples from Indian traditions. And here I would spend next 5-7 minutes, if it is all right, to explore a little bit about the whole path of dharma.
It is all right, dear Nanta. Okay. Mm-hmm.
And so
it is very interesting for us. Excuse me.
Okay. So I would take another 10 minutes or so, and in the process I will explore a little bit more on the idea of dharma, and then understanding its planetary significance. How dharma, though the language may not be familiar, but it corresponds to many of our normative concerns as well as practical concerns. Now, the great legal scholar Robert Lingard, in his book The Classical Law of India, he writes, "The modern legal system in the West is a system which fits an egalitarian and individualistic society. It starts with the individual and is a manifestation of their own picture of the social order. The classical legal system of India substitutes the notion of authority for that of legality." So here we are invited to think of the relationship between authority and legality. The precepts of Smriti is part of one memory tradition in India, are an authority because in them was seen the expression of a law, but it has no constraining power by itself. Society is thus organized on the model of itself. So therefore, the society also has to organize itself, the self-organization of society. The societal preparation is very important, and law as an element of the social system cannot be just closed within itself. The classical Indian tradition had a different conception of both rule of law compared to modern Western tradition. While the constraining power of legality is central to modern Western tradition, in India it is moral authority which is at the core of the role of law. So moral authority, and that moral authority is also spiritual authority. But because there is moral authority and spiritual authority, that does not mean that there is no accountability. Because we know there is also the perennial challenge of abuse of authority. So therefore, when we talk of moral and spiritual authority, there were certain checks and balances built, how that moral and spiritual authority can be responsible, can be accountable, both to the self, both to the divine order, as well as to the legal and political order. The classical law of India is characterized not by positive law and legality, but by moral authority and duty, what is called dharma. Dharma refers to the totality of duties which is incumbent on individual. Dharma also signifies eternal rules which maintain the world. The rule of law entailed in the rule of dharma in classical Indian tradition was part of a transcendent engagement. Again, transcendence is very important. But dharma was a point of connection between the transcendental realm and the life world and the societal world of individual. The object of dharma was to create a better world where individuals and societies could attain divine self-realization and societal co-realization. The rules of conduct and duties which it enunciates are preconditions for the realization of social order as it was intended by the Creator. So the divine also had a great role to play. And we would have to look at the divine in an open way, because some people believe in a personal God, some people do not believe in a personal God. Like in Buddhism, there is the notion of an impersonal divine, and in the indigenous spiritual tradition. So we would have to incorporate the divine in an open way. Rules in classical India were thought to be of divine origin, but in the Western tradition, law has been thought of as part of a conscious deliberation of individuals in societies. While law is of divine origin in classical India, custom is much more to the ground and it is much more part of social making. Unlike law, custom is purely human development in the sense that it develops at the level of human groups involved. However, unlike Roman jurisprudence, the origin of custom in classical Indian tradition is again attributed not solely to human and societal deliberation. Its origin eludes human memory, which confers upon it almost sacred character. And that custom also has a point of critique. It means that because it is customary, that does not mean that we have to obey it all the time. We also have to bring our reason here. And here Buddha, you might have heard about Buddha. Buddha always said that when we are living, O Kalamaj, he was walking from place to place. And when he come to a tribal people called the Kalamaj, he said, always look at your custom, your habit from the point of view of reason. And then what happens that when we do not follow law and dharma, which is right conduct, and then there is anarchy. And that anarchy is both social anarchy as well as anarchy of the soul, anarchy of the cosmos, anarchy of the society, and anarchy of the individual. And according to another great Indian thinker, his name is Rameshwar Roy, he's saying that the anarchy happens when there is the law of the fish. And it is a very interesting metaphor, dear friends, to pluralize mythology. Now, we are familiar with the law of the jungle, and when the big tigers can eat the small one without any consideration. By the by, animals are far more considerate than human beings when it comes to non-purposive killing. And in Matsyanaya, in the law of the fish, in the sea, in the pond, it is the big fish which eats up the small fish. And therefore, the challenge before law and justice, how is to prevent that? But that happens at the level of individual when we become greedy, and it also happens at the level of society and polity when the rulers become greedy and authoritarian. So then if this is the condition, then how do we overcome greed? And therefore, dharma is to overcome our greed, both at the individual level and the societal level. And that overcoming requires a turning around or turning point. And therefore, this turning around is necessary. And therefore, if we do not turn around, and this is also a very important theme in contemporary critical legal discourse. For example, Teresa Brennan, in her work on evil, she says that unless we control our propensity to control and dominate others, then we are already always imprisoned within social evil. And therefore, the future of law is to overcome this imprisonment in our own anarchy in the soul, where we become slaves of greed and desire, and also at the societal level. So therefore, dharma as a practice calls for both appropriate self-formation. That how do we become, for example, more better individual? And here we can think of Kant, for example. Kant talks about the kingdom of end, E-N-D. And so how does law helps in creating a kingdom of end? But then our means is not just any evil means, is not just a means to an end, but how do we become end in ourselves? And that is also the challenge of law and dharma, that modern law has been too instrumentalized. How do we bring a sense of intrinsic worth to ourselves? We would have to rethink the relationship between means and ends. And that is also the challenge that the Gandhi, for example, Gandhi always said that it is as important to think of means as it is important to think of end. So then very quickly, I would like to move on by saying that this whole idea of dharma, then it requires self-rule. That we would have to learn how to rule ourselves, as also we need coordinating mechanisms of societal rule and regulation. But self-rule is very central. And that is the idea of self-rule. But when we have self-rule and when society also becomes self-governing, you know, there is the very idea of autopoiesis. How do we become self-poetic, self-governing? Then that would be a different future. Today, we are too much controlled by external agency. With that, then, we would have a different conception of power. Because so far, law and power has been used to either punish or to dominate others. But how do we create a different conception of power? For example, when power in self-rule, when, for example, myself or Gyan Luigi is becoming a self-ruler, now when or Valentina is becoming a self-ruler, the power that Valentina would use upon herself would not just be throwing herself to, you know, sending her to Siberia or to Guantanamo Bay. You know, there are some difficulties with myself. Does it mean that I would have to, you know, push that into a Gulag archipelago? No, I would have to learn how to work with myself. So that power is not just controlling and annihilating, that power is reconstitutive. So therefore, so the future of law, therefore, as it interacts with law, and again, here I'm reminded of that epochal sentence by Lord Jesus Christ in Bible, love is the fulfilling of law. So, and that is a perennial challenge. Then how do we practice law? And you know that if Derrida also has talked about friendship, Gandhi has talked about friendship, Hannah Arendt has talked about friendship, and also another great contemporary women philosopher, Luz Irigaray, also talks about love. You know, so I think I am slowly reaching the time, so I would like to conclude, you know, in 1 or 2 minutes, you know, and by saying that how the future of love as it relates to love, for example, how love is also multidimensional. Love is not just, you know, love is also compassion, but love is also confrontation. So how do we create a confrontative compassion? And as Luz Irigaray would say, that what has happened today is in modernity, there is the denigration of the body, you know, and legal positivism also looks at body. We put the body into the prison, but we know even if we put the body into the prison, the soul is free. And therefore, you know, one of the great reform that we need, and that is the reform of humanity. How do we reform prisons, for example? Again, think of Dostoevsky's Crime and Punishment, you know. And today, the conditions of the prison are like hell. Now, if we put our bodies and mind into such prisons, now what kind of restitution is possible? So the point is that how prisons also becomes gardens of love, and they become laboratories for a different kind of self-formation and societal formation, and how here the great work of Tolstoy, Leo Tolstoy, and he was a conscientious objector, you know, and he supported the Doukhobors. The Doukhobors were pacifists, and they didn't want to take part in the process of killing. And then they raised consensus, and Doukhobor and Tolstoy supported them, and that is also the part of great history. People like Peter Kropotkin from Russia, who talked about mutual aid. So building upon these multiple narratives, multiple stories, multiple mythologies, we create a new mythology for our time. And I would conclude this idea of justice by saying that justice is not enough. We would have to link law and justice to responsibility. And that responsibility is that nobody is not free from responsibility. All of us, again, as Dostoevsky would say, we are responsible all the time. And how do we embody our responsibility? And that responsibility is sharing. And as Paul Ricoeur, the great philosopher, who built on both spiritual tradition and rational tradition, he was a deeply inspiring Catholic practitioner. And we also can bring up different traditions of practice of mercy and compassion, as Pope Francis is talking about a new social fraternity. His last two encyclicals were an encyclical on nature, Laudato Si, and also the last encyclical was on social friendship and fraternity. I would conclude with this thought of Paul Ricoeur, who is saying that when we are thinking about justice, we always think of share, like what is my share of? For example, share of in the sense of justice that I would get if somebody has hurt me, if somebody has done illegal things to me. And Ricoeur would say justice is not only share of. What is my share of the share? You know, now the share market, is my share 50% or 70%? As President Trump would say, what is my share? What is the price of my share? But as President-elect Joe Biden would say, it is not enough to talk about what is my share, but what is my compassion? Am I compassionate to a person who is dying? And Paul Ricoeur would say, again, I am not making a political statement here. I give my love to both President Trump as well as President Putin in Russia, and then President-elect Joe Biden, to say that the challenge before us is whenever we are in hospital, and at that time, law is not enough. We need mercy, we need compassion. And therefore, Paul Ricoeur would say, do we know how to share in? Do we know how to share in our love? Can we share in, if I have a little piece of cake, can I share in with we? As having a proper share of the cake is important. But even if I have got a share of the cake, can I share in with others? And that sharing is not limited only to citizens of the land, only to fellow Russians, Indians, or American. Not only American first, Indian first. How do we share in with our humanity? So future of law depends upon our ability to share in. And again, as the coronavirus is knocking at our door, not only share in with human beings, but also with the virus. Virus is not our enemy. Virus is a messenger of the unsustainability of our present condition, and it is a challenge for us to create alternative futures. Spasiba. Spasiba.
Thank you very much, Dianand. So Professor Giri had a very emotional and a very wise presentation. So thank you very much. I hope that you are now our best friend and would be also, because I think we think like you. Your ideas are very huge and great for all humanity. And I hope that everything you wish for us as a humanity will be, and our future would be more better like our present time. So I'm sure that for Professor Giri will be very interesting in your remarks. So please ask him the questions. Maybe our new friends, our new colleagues wants to ask questions. So could I first speak about, at first you said about a lot of persons and a lot of philosophers and also lawyers. And what for your reason is the best theory for you now in jurisprudence? What law school you prefer? You spoke about Habermas. I like him very much. His theory, of course, he's not only a lawyer, he's a philosopher, but maybe you can explain us what theories for you are the best now. What do you prefer?
Thank you. Thank you so much, dear Victoria, and for your kind comments also. Thank you. And now, regarding schools of law or thoughts about law, and I wish to say that I am not a trained lawyer or a legal philosopher. At the same time, humbly, I draw inspiration from some contemporary writers. And here I think, I have learned quite a lot from Habermas, for example, and that idea of discourse and how law becomes a space of moral discourse, and how law becomes a laboratory of moral development that I would value. I also deeply respect the work of Ronald Dworkin, and Dworkin, who talks about law and interpretation, and that I relate to many interesting Indian thinkers as well. And in India, we have a very, very creative and critical legal scholar and thinker. His name I didn't mention, but let me mention his name. His name is Upendra Baxi. And his last name is Baxi, B-A-X-I. I would later email his name and some of his
Thank you
works.
very much. Mm-hmm.
Yes.
Yeah. I wanted to that you write me about him. Mm-hmm.
And just to bring Professor Baxi here is that Professor Baxi also and understand the limits of law, and how law is very much entangled in the apparatus of the state and systems of justice. And therefore, how acknowledging that entanglement and imprisonment, how do we create possibilities for emancipation? And how law also becomes a tool for emancipation. And so these are some of the thinkers. And I also think greatly about the work of Roberto Unger, who developed this critical legal studies movement. I'm sorry, my familiarity with Russian legal thinking is at the moment elementary, but I would also like to read about thinkers of creative law from the Russian tradition.
Mm-hmm. Thank you very much. I hope you will see our works too, and I think I will think about that you should know much more better about Russian lawyers, Soviet lawyers, and our present lawyers too, because we should say that our Russian lawyers, the lawyers of the 19th century, is our gold school. So it is the best. It was and it is our progress. They could write and speak different languages. They had a huge of communication with Germany, French, Great Britain, and so they wrote a lot, especially Romanish law, and it was a great school. So thank you very much that you are interested in this topic too. So maybe somebody else wants to something to speak about Professor Giri and have questions. Gianluigi, yeah? Yeah, but you, okay.
If somebody else should speak, I can give the way. That is, would somebody else speak, or may I speak? May I ask a question? Because I greet you, Ananta. Thank you very much for your brilliant exposition. I would like to tell a question, that is, you mentioned Dworkin, Ronald Dworkin. I would be interested whether, as regards the Indian laws and interpretation of laws, the majority or minority of legal scholars are oriented towards Dworkin or towards the tradition of legal positivism, because there is always this great contrast between the two legal currencies in the United States, not only in the United States, because it is in Italy so, it is, you have Dworkin and the theory that there is, so to speak, an amount of moral comprehension which is over and above the legal system. We should so, it ought to be so. Whereas there is the tradition of legal positivism which says no, not at all. There is nothing which precedes the legal order, and there is no point in saying there is an ethical environment, an ethical thought which precedes the concrete legal system. And if I am not mistaken, if I understood right what you said, you side with Dworkin and not with legal positivism. I would like to know, to ask whether there is a similar debate in India, because it is always very rich. Thank you. Thank you very much.
Thank you so much, dear Gyan. Thank you. Thank you. And yes, now the challenge before us is to understand the challenge of interpretation vis-a-vis the dominant realm of legal positivism. And in India, now, of course, legal positivism as a paradigm is in place, the dominant legal system, but some scholars and some jurists, some justice also, some judges, they would like to open up this legal positivism in this way, that it is mainly Euro-American law. And then how that Euro-American law also has to dialogue with conceptions of Indian law. And as I was mentioning, that if our motto of justice is not just punishment, but also restitution, then how do we create, how do we understand the many interpretations of effect? And that way, we have a very respected judge in India. His name is Markandeya Katju. And in his reflection on justice jurisprudence, he's trying to build on certain Indian traditions of jurisprudence, where when we are confronted with many kinds of, it is not just that one is right or one is wrong, but when is simultaneously one is right and another is right to some extent. How do we make a decision? So Katju is inviting us to build upon this kind of legal traditions, which are much more open than just black and white. And at the same time, that new kind of interpretation is very important. As we might also remember here, Stephen Toulmin, his work on casuistry, and how that casuistic thinking also has been part of modern Western legal thinking, and that sense of, therefore, there is a limits of positivism. And that limits of positivism is happening through these three movements. another great Indian philosopher, R. Sundararajan, in his book 20 years ago, he's talking about 3 post-positivist terms. One is the linguistic term. And that linguistic term is that even the language of law is a language in the sense. And how do we understand that language in a sense of open language? It is not just a sense of sign language. And when that language has multiple symbols and, and symbolic dimension of language, so that linguistic turn is important. Second is the ecological turn. And that ecological turn is also challenging legal positivism, for example, environmental law and happening today with the virus. And but that ecological turn. And the third is the feminist turn. And I think that whole sense of gender. So all these movements are very important part of the post-positivist turn. And I think even hard rock positivism, legal positivism, has not been totally non-affected by it. So everywhere, and I think in India also we find new movements, new kinds of feminist law and things like this. For example, how do we think of marital rape, for example? How do we think of violence within marriage? So all these are, important challenge. So my journey, my submission then, that let us move with positivism and beyond, and let us practice creative movements of interpretation and new kind of hermeneutics, which would really move across multiple domains, law, justice, responsibility, soul, nature, and divine.
Thank you very much. And Diana, another question from me. And what is the justice for you? For example, justice, as I understood, for you, justice is in our life, not in our legal terms. Or am I right or not?
Yes. Now, justice is a multidimensional journey. And for example, justice is a process.
Mm-hmm. Mm-hmm. And your history, your Indian legal...
Can you hear me now? Can you hear me?
Yeah. Yes, very good.
So I'm saying that justice is a multidimensional journey. Mm-hmm. And then it would have component of, for example, being just. If I have been done wrong, then it would have a component of mitigation, but also it would have the component of communication, of reconciliation. And so therefore, it is not just punishment and revenge, and it is not just what is my share of. So justice is multidimensional. And justice is simultaneously individual and relational. So how we have justice, if I have been treated unjust, then creating a condition for me to be treated just, both individually and collectively. And then it has its manifold implication. For example, justice has an economic dimension, economic justice, for example. Now today, and economic injustice is a crime, and look at climate change today. Now, most of the people who are vulnerable, now they are going to go underwater. And now, who is responsible for that? And so therefore, we would have to bring a sense of justice, in the sense that how do we become responsible? How do we be held accountable? So then we would have to think of economic justice, political justice, also justice of dignity. Now, many times our languages, our cultures are being annihilated. Now, if, again, speaking about language, now if a country has a dominant language, but it has many languages, my language may not be spoken by 80 million people, but even if it is spoken by 10,000 people, that I have a dignity of existence. So that cultural justice, So we would have to be attentive to. And then finally, the justice of life, because so far justice has been anthropocentric. But justice is not only for human beings. How do we, for example, cutting down trees, and it has been a crime in many traditions. If you cannot just cut down tree. So similarly, we cannot just beat animals, because there is animals. So all these kind of cruelties and everything. So how do we move from entrenched cruelty to non-cruelty vis-a-vis our relationship with nature? That is also part of work of justice today.
Thank you very much. Maybe our new guests, dear Mary Kakravarti, wants to speak about something, to ask dear Ivanti. Okay, and have any questions?
May I? Dear Professor Giri, how do you think, how will develop legal cooperation between India and Russia, and what a place the India Law School take in this cooperation?
So thank you, dear friend. And what is your name, please?
Vladimir.
Vladimir.
Yes, I'm Vladimir.
Yeah, like our president.
Okay. Thank you. Thank you, dear Vladimir. And are you also from St. Petersburg?
No,
no,
we all are from Moscow, not San Francisco. I was born in St. Petersburg, but we are right now in Moscow.
Yes. Now, yes, it would be lovely to build legal cooperation. And in India, some law schools are very open-minded. And they are doing very interesting legal theory, cosmopolitan law, and it would be possible to make connection with them. And then the second thing is to think of a seminar, a workshop and a book project on, for example, new, creative alternatives emerging from legal thinking in India and Russia. And so that way we can build a cooperation. And I wanted to suggest that I'm editing a book I'm co-editing a book with Russian colleagues called Social Theorizing in Contemporary Russia. And their legal theory would make a very important part. So there I would invite both you and Valentina to think of a contribution on new developments in contemporary legal theory. And from there we can think of joint cooperation of workshops, seminars, and also when COVID permits, visiting each other.
Thank you very much. And I want to say that just now I have sent for scientific leader for Professor Isaev your books. So everything is okay, and we will have a great pleasure to read, because as I said, your views are the same. It's very interesting, and I wonder why, because we think together the same. It's the great, super. So thank you very much, dear Professor. So thank you. And I want to say that I would like to congratulate you on your excellent report. It was very poetic. And I want to say for each other that Professor Giri is also a poet, and for example, he also sent me his book, Waving Your Hearts. So right now, I want to say that your item, that your topic, your problems are in our hearts and in our mind. Thank you very much, and I hope we will be the great, we will have a great cooperation, integration, collaboration, so all you wish. Thank you very much.
Thank you, Pasiba. Pasiba, dear Victoria, Pasiba,
Excuse me, I'm Valentina, not Victoria.
Professor Igor, Gianluigi. I'm sorry, Pasiba, Professor. I'm sorry again, just to misspell your name.
Okay, it's all right. Yeah, we have very different names, and for us, it's also very difficult to your name. So it's everything. It's okay. So thank you very much, dear friends and colleagues, and I will call upon our great friend, our moderator. So the next report will be liberalism, autonomy, diversity, education, irrational reasons. Our great friend, Gianluigi Segalebra, so expert analytic from Italian press, from Austria.
Thank you very much. Thank you very much. I hope you can hear me good, or can you hear me?
Yes, very good.
I had some problems in the beginning. That is, perhaps you have noticed I was not in the video and my connection collapsed because, well, there is a famous film in the United States, Postman Always Rings Twice. It is a thriller which was many times filmed. And unfortunately, I must say, this time the postman rang 10 times. I had really very many problems. I thought there is a fire. So I lost the connection, but anyway, now it seems that everything functions. I thank you very much, of course, for your invitation. I thank you very much for the members of the organization. I would like to speak about this theme, that is liberalism, autonomy, diversity, and education. Because it is a subject which at first sight can give you and me the impression that there are not so many connections with the legal system, but this is not true. It's not true if we take into consideration a particular problem which originated in the United States 1972 with the sentence and decision of the US Supreme Court. The problem is this, and this perhaps can clarify whether and why the problem of autonomy is connected to the legal system of the United States, but not only of the United States. Can you hear me speak too rapidly? It is good how I'm speaking, or I speak too rapidly it's good. Can you say me? Because, well, you know, Italians have many defects, and between these defects, there is also that we speak too rapidly. And so the other people say, no, please speak slowly, because speak more slow, because we cannot follow you. I am sorry. Well, if I speak too rapidly, please tell me. Well, the point is this: there is a decision, I can here short introduce to autonomy. You see, as autonomy, I have given this definition: autonomy, development of reflective capacities in time examination of traditional values. Connected to this theme is the debate of the existence of a right and even of a duty from the state in defending and in promoting autonomy of the individuals, of course. The corresponding question is whether the state has the right to defend the autonomy of the individuals in relation, for instance, to the group to which they belong, and whether the state has the duty to intervene for the promotion of the autonomy of individuals against the group to which individuals belong. In particular, the subject of the education of children is strongly connected to the mentioned themes. The defense or even the promotion of autonomy of individuals from the state can collide in case of the question of the public education of the children with the rights of the parents. This is the problem: to choose for their children a determined way of education and determined way of living. And we will see how this is connected to the United States, but not only to the United States. Some elements taken from the legal states in the Council of Common Law could help to bring forward the discussion. Perhaps we can go My analysis will, moreover, deal with the concepts like the possibility of the presence of a value pluralism in society and the compatibility between freedom and multiculturalism. Furthermore, I will examine the question of whether the educational system must reckon with the presence of different cultures in society, or whether the educational system ought to be uniform for all children. These are some questions. In order to offer a description of different interpretations proposed on these themes, I shall begin my analysis on the debate regarding the sentence Wisconsin versus the other. In order to investigate from this debate, I shall take into account this position of Feinberg, of Elster, of M. Gutmann, of Richard Anderson, of Shinan Shapiro, of Gelston. There are only some of the questions, but this will come thereafter. The first thing is to see the particular problem, and to see why this particular problem, because one could say, well, it is only a sentence decision of the Supreme Court, it has no so great relevance with all the question of education, of autonomy, of children's rights, of relatives' rights, of parents' rights. But it is not so. No, it is a sentence, a decision of the United States Supreme Court, which originated in a juridical legal earthquake, and we'll see why. Now I will perhaps go to my text. I would only like to say that, of course, I can send you my complete PowerPoint and my text. There is no problem. Everything is at disposal. You can write me through the chat line, or you can write me to my address on Gmail. Well, I can send you then my Gmail address. So, which is the problem? The problem is this. It began 1972. In 1972, there were 3 Amish students. Amish are a particular Christian confession. Perhaps somebody of you knows the film The Witness with Harrison Ford. Perhaps not, but anyway, it has no so great relevance which sort of confession it is. The problem was this. 3 Amish students from three different families were withdrawn from school in New Glarus, Wisconsin. The name of the school was New Glarus High School, after the end of the 8th grade, because of the religious belief of their parents. The problem was, Wisconsin Board of Schools has said, well, now we have for the children 10 years compulsory school. That is, every child of Wisconsin has to go to school compulsory for 10 years. And the Amish families, these 3 Amish families did not agree with this decision, because they said, no, if this is the case, then we risk that our children will leave our community. And this is a damage for the First Amendment, for this contravenes the First Amendment of the US Constitution. It goes against the possibility of exercising our religion. Shortly said, the First Amendment of the US Constitution says, among other things, that the Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. That is, Congress, the civil authority in the United States, may not do a kind of law, of disposition, or something else which goes against the free exercise of the religion. And the Amish family said, if you compel our children to go 10 years at school, they will leave our community. So you go against the free exercise of our religion because you damage our community of religion. This is the problem. That is, on the one side, there is Wisconsin Board of Schools, which says, from now, in 1971, 1972, children must go 10-year compulsory school. 10 years. And on the other side, the Amish family said, no, if you compel our children to go 10 years compulsory school, there is a higher risk that our children will leave our community of religion. Therefore, what you do is simply to contravene to the free exercise of our religion. That is, you go against the US Constitution. These are the 2 points, the two point term of the debate. And now we have to analyze a little bit in order to understand the huge consequences of this contrast between the two factions, the two rivals, what the US court said about this question. The three families were represented by Jonas Yoder, therefore it is Wisconsin against Yoder. Yoder was one of the fathers involved in lawsuit. The families at first lose before the US court. The family lost the case in the Greene County Court of Wisconsin. But they decided to appeal against this decision. And the Wisconsin Supreme Court decided, Wisconsin Supreme Court, not the US Federal Court, the Wisconsin Supreme Court decided in favor of the family. 7-0, that is, there were 7 judges, 7 justices in the Supreme Court of Wisconsin, and they all unanimously said, no, families are right, and the state of Wisconsin is right, because you cannot go against the First Amendment of the US Constitution. If you say 10 years compulsory school, you violate the First Amendment of the US Constitution if you violate the free exercise of religion. The Supreme Court of Wisconsin motivated its decision on the basis of the fact that compulsory school attendance would violate the rights of the parents under the free exercise clause of the First Amendment. Then now it's the Wisconsin Board of Schools who is does not agree with the decision, and the Wisconsin Board of Schools appealed to the United States Supreme Court. Okay. Before there were the Wisconsin Supreme Court, now there is the most important court of the United States, the United States Supreme Court. And well, now is the question, what happened? We are 1972, that is nearly 50 years ago, 48 years ago. It is always interesting to make here a little experiment. That is, if I am trying to see you, if you want to, you can tell, of course, who knows the decision of the Supreme Court should say nothing, but all those who do not know which part took the United States Supreme Court can say, for instance, what do they think? That is, what did the US Supreme Court do at the time, 1972? They said, well, Wisconsin state has decided 10 years compulsory school, and in our opinion, Wisconsin state is right, and the families of this confession, this Christian confession, are wrong. Or the other way around, that is, they said, no, in our opinion, the families are right. 10 years compulsory school means that there is a risk that the children then say, well, we do not know, have any more to do any Anything has to do with the community of the Christian confession, and we leave the confession. And well, what do you think if you want to see who won the cause before the U.S. Constitution, U.S. Supreme Court, the families or the Wisconsin Board of Schools? If you want to, you can say it. Of course, I am going to tell you who won. You can write in the chat line, or you can counter, but it's always an experiment, really, because it is always a surprise, the result. There are these two parts. On the one side, the feminists would say, we want to defend our right to the free exercise of religion, and 10-year compulsory school means that we are violated in our right to the free exercise of religion. And the Wisconsin Board of Schools would say, no, we want that children goes to 10 years in school because this is good for their formation, for their education, this enlarges the perspective of life, the possibility of life, and so on and so forth. And the question is, Supreme Court was formed at that time by 9 components, 9 elements, 9 justices, 9 judges, but only seven of them took part in the decision. And of course, they had to decide which part won, in your opinion. If you want, you can tell. So it is only an experiment. But it is not compulsory, really. If you do not want, I can tell you immediately. I can tell you. Should I tell?
Yes.
Yes. Well, you will probably find different results, because in some legal apparatuses you find 7-0. In some legal apparatuses you find 6-1. But anyway, the U.S. Supreme Court of that time said the families are right. The families are right. That is, if you give 10 years compulsory school, you go against the free exercise of religion. That is, you may not oblige children to go 10 years to school, because otherwise you violate, excuse me, the free exercise of religion. 6-1 or 7-0. It depends, because I never found a definitive assessment. There was a partial dissenting opinion. I can then read it to you. I have it. But anyway, the problem is it was only partial dissenting opinion of a judge. Therefore, sometimes you find 6-0 or 7-0 or 6-1, depending on whether this dissenting opinion is counted against the decision or not. But anyway, one is clear: the family won. And now we have a problem, because the first time I studied this case, I said, well, it's only a decision, particular, it has nothing to do with other questions. It it involves the Wisconsin Board of Schools and these families. But it is not so, because there was then immediately a huge discussion in the United States schools, and not only in the United States schools, but practically immediately in every English-speaking territory, that is in Australia, in United Kingdom, and in Canada, and in New Zealand. in order to comment on this decision, because the point was, if you say that the free exercise of religion is prevalent on the education of children, you say first of all that the parents have a sort of possession of children because the parents had decided, and secondly that, so to speak, the respect of the free exercise of religion is more important than the enlargement of mentality of the children. That is, you say there is something more important than autonomy, and therefore the question was, should for instance schools promote autonomy or not in their system? This is the question. This was the question. And there are different positions of different commentators, of different scholars. But before going to the comment on the different positions, some different positions, it would be very long to comment on everything, but I would like to give you some suggestions for discussion. I would like to read you something of the sentence why the US Supreme Court decided this way. The US Supreme Court held at that time as follows. First of all, states cannot force individuals to attend school when this infringes on their First Amendment rights. In this case, the state of Wisconsin interfered with the practice of a legitimate religious belief. Second, not all beliefs arise to the demands of the religious clause of the First Amendment. There needs to be evidence of true and objective religious practices instead of an individual making his or her standards from such matters. But the Supreme Court says the Amish way of life is one of deep religious conviction that stems from the Bible. It is determined by their religion, which involves their rejection of worldly goods and their living in the biblical simplicity. The modern compulsory secondary education is in sharp conflict with their way of life. Third, with respect to the state of Wisconsin's argument that additional modern education beyond hate drugs is necessary to prepare citizens to participate effectively and productively in America's political system, the court disagreed. It argued that the state provided no evidence showing any great benefit to having 2 extra years in the public schools. Furthermore, the court contended that the Amish community was a very successful social unit in American society, a self-sufficient, law-abiding member of society, which paid all of the required taxes and rejected any type of public welfare. The Amish children, upon leaving the public school system, continued their education in the form of vocational training. And for the court found no evidence that by leaving the Amish community without 2 additional years of schooling, young Amish children would become burdens on society. To the contrary, the court argued that they had good vocational background to rely upon. It was the state's mistaken assumption that Amish children were ignorant. Compulsory education after elementary school was a recent movement that developed in the early 20th century in order to prevent child labor and keep children of certain ages in school. The state of Wisconsin's argument about compelling the school attendance were therefore less substantial. And then they said to the dissent of the judge that the question before it was about the interest of the parents to exercise free religion and did not relate to the child's First Amendment rights. As such, the argument pertaining to the child's right to exercise free religion was irrelevant in this case. It is interesting to, perhaps, in order to see to the end how the question in the U.S. Supreme Court was, part of the dissenting opinion of the only judge who was who did not agree with the other judges and who said, no, the question cannot be solved that way. He said, among other things, if a parent keeps his child out of school beyond the grade school, then the child will be forever barred from entry into the new and amazing world of diversity that we have today. This was one of the objections to this decision of the judges. Now, we have to see some aspects of the debate on this sentence. The sentence is this: there is school, okay, but there are also some other values, and if there is a choice between school and religion, the decision must go towards the right of the religion. And it can quote perhaps something which is just been written in the last 40 years after the sentence. For instance, some important, in my opinion, some important commentaries, reflections have been made by Professor Amy Gutman. She is professor at the Philadelphia University, and she criticized this kind of decision of the US Supreme Court. She says, for instance, her principles are the following one. First of all, there are primary goods in life. These primary goods are not expendable, and civic education and school education, among other things, is one of the primary goods. That is, it should have the precedence. The life dimension of the children may not be limited to the community or to the family. A plurality of models to be acquainted with is indispensable. You cannot say there is this community of religion and children have to be part of this community of religion and everything else should not be taken into consideration. No. You have, in opinions of Amy Gutman, you have to educate the children for a number of years to independence. Then if they don't want to go to the civil society and they want to remain member of a strict community like Amish, they can do it, but before you have to furnish them with the necessary, indispensable education. If you cannot say no, I retire, I withdraw the children because otherwise they are corrupted by the civic education, by education in school. And I can quote something of her. For instance, she says something like this. The most obvious primary goods we as a rational person would want provided to us as children are adequate nutrition, health care, housing, familiar affection, and an education adequate to choosing among available economic and social opportunities and to becoming informed democratic citizens. Yet, from the point of view of some citizens within our society, even this short list is controversial. Many Jehovah's Witnesses and Christian Scientists do not think that their children should be forced to take certain medicines or undergo certain medical treatments that are necessary to good health and normal physiological development, and sometimes to life itself. The old order Amish do not believe that formal secondary education is the primary good in our society. But these examples need not upset the plausibility of a primary good standard of paternalism applied to children. She said, for instance, something. For instance, rarely, if ever, does a family furnish its children with a broad range of resources and opportunities to choose among free and adequate adult life that does the wider society. While parents often do give their children some of the essential goods of life, they still have a duty to permit, if not to prepare, their children to choose among a range of conceptions of the good life that differ substantially from those held by their family. As citizens of a society offering a broad range of choices to its adult members, parents have an obligation to allow their children to be exposed to the choices available in their extra-familiar society. That is, you cannot, what Amy Gutman says, you cannot organize education so that education is only there in order to perpetuate a particular community of religion. You cannot say, no, these children should remain in our community, and all which can eventually so make that they leave the community must be abandoned, must be not taken into consideration. She says, if my argument so far is correct, it will not suffice to claim that the Amish community has the right to impose its standards upon Amish children. Even if the Amish community were an economically and politically self-sufficient unit within our society, the Amish should still have a duty to expose their children to a greater range of choice, and they now do. If they were self-sufficient enough, it might be the case that no state surrounding the Amish community would have a clear right to intervene in the education of Amish children so as to enforce the duty of Amish parents. The parental duty, nonetheless, would remain. Of course, the Wisconsin Amish today are not a self-sufficient community, nor do they provide their children with as broad a range of choices among good lives as the larger society does. And then she says, for instance, we must briefly examine the meaning of a child's right to education within a liberal society. If children have rights in virtue of their basic needs and interests as future able citizens, one of those rights will be a right to education, or what some theorists have called a right to socialization. The content of children's right to education will depend upon what is adequate for living a full life within their society, for being capable of choosing among available conceptions of the good and of participating intelligently in democratic politics, if they so choose. I have no doubt that this criteria impose substantially greater obligations upon us than we fulfill by our current educational and other related practices. But beyond this point, education ceases to be a right, even if it remains an important human good. On this understanding, the child's right to compulsory education is a precondition to becoming a rational human being and a full citizen of a liberal democratic society. Without any formal schooling, children will be incapable of intelligently exercising their civil or political rights within our society. The assertion on the part of the parents of an consented right of free exercise therefore entails the assertion of a right to deprive their children of two fundamental goods for which a liberal democratic state exists: the making of an informed choice among components of the good life and participation in meaningful democratic self-government. So paraphrasing, she says clearly, so you cannot organize education in order that education only serves to perpetuate the community. You cannot say, well, we old order Amish want that our children do in the future what we have done, and education should be so organized. It is, the children are preordained to remain in our community. Education and autonomy should not be so. Education, school education, civic education in the society should give every child the possibility to choose among their own future. You cannot say these children are our children and therefore they must do what we have decided for them. This is the position of Amy Gutman. So, in a sort of formula, she says then, without education, liberal freedom lose a great deal, even if not all of their value. Can go now to another, for instance, for two other authors, which are, in my opinion, very important. Irrational and Shapiro. I can then show you through my PowerPoint. And also Anderson and Shapiro criticized the decision of the US Supreme Court. And they say among other things, excuse me, they say, we suppose that a significant aspect of citizenship includes the requirement that people have the capacity to vote in an informed way in elections that determine the membership of legislative assemblies, as the content of the laws, as well as the identity of public officials and judges who execute and apply the law. To be able to participate competently in democratic decision-making, voters should have an adequate knowledge of the contemporary science in its bearing on public issues and understanding of modern world history, and particularly the history of democratic institutions and the culture of their own society. And critical thinking skills that include the ability to represent the situation of others in imagination, to intuit their experience, and sympathetically to analyze and assess their attitudes, principles, and policy arguments. Citizens should have the capacity to keep themselves briefed on current events relevant to governmental decisions we make. In a diverse democracy composed of disparate creeds, faiths, races, worldviews, and concerns, arriving at fair and reasonable decisions about public policy is a task of delicate and complex judgment. That is, it is clear the position, of course, I could read very many things that Irrational and Shapiro have written in their interesting study, but the point is this. There must be education, first of all, school education, and school education has the duty and the aim to prepare the scholars, the students, the children, the pupils, for an adult, mature life without participation in the public community. That is, education should not serve to perpetuate a particular order of religion. The education should give the possibility to decide of one's own destiny and to be able to understand what is going on in the society in which the future adults, the children of now, live. And therefore, they say, U.S. Supreme Court has not taken in the due recognition this point. You cannot say there is a First Amendment, exercise of religion, and that's all, because the life of the children does not function this way. Well, now I can make a spring. Of course, I have materials for you if you want to read more. The question of the interpretation of Irrational and Shapiro, but up to now we have seen, for instance, there is a huge number of commentators of the sentence decision of the U.S. Supreme Court. Our first two positions are absolutely against the position of the U.S. Supreme Court. Now, perhaps I could quote you a commentator who is, on the contrary, for the decision of the U.S. Supreme Court, because it's interesting. His way of interpretation is interesting. I can search it for you. Excuse me.
Some problems?
Yeah, no. I should have no, it's okay. So the point is, which is the fundament, the foundation of the two criticisms of the U.S. Supreme Court decision, is this, as a synthesis. There are some good, social goods, like, for instance, education, autonomy, and so on. And for instance, autonomy is the supreme good. That is, if you want to have adult, mature citizens, you have to implement and to promote their autonomy, their capacity of thinking with their own brain, so to speak. And this is the common point of Ernst and Shapiro and of but not everybody thinks so, because not everybody thinks that there is a supreme social good like autonomy. For instance, another interpreter, which is William Galston, who was for many times special counsel, special advisor of former President William Clinton, he says that autonomy is not the greatest virtue of the citizen. He says, for instance, something like this: objective goods cannot be fully rank ordered. Social goods cannot be fully rank ordered. This means that there is no common measure for all goods which are qualitatively heterogeneous. It means that there is no summum bonum that is the chief good for all individuals. It means that there are no comprehensive lexical orderings among types of goods. It also means that there is no first virtue of social institution, but rather a range of public goods and virtues, the relative importance of which will depend on circumstances. That is, so translated into our debate, it says, for instance, well, of course, autonomy, education, culture, free thinking are social goods of persons, but they are not the only one. It is absolutely not said that these social goods are more important, for instance, than the free exercise of religion. Who can say that? Who has the authority to say free education is, or autonomy of the person is more important than to live in a community of religion? Who can say that? Please. Who can say that this is absolutely more important? This is the way of argumenting of Galston. Galston says, with reference to the sentence of the decision of the U.S. Supreme Court, he says, for instance, consider finally the case of Wisconsin versus Yoder, decided by the Supreme Court. This case presented a clash between a Wisconsin state law, which required school attendance until age 16, and the old order Amish, who claimed that high school attendance would undermine their faith-based community life. The majority of court agreed with the Amish and denied the state of Wisconsin had made a compelling case for intervening against their practice. However strong the state's interest in universal compulsory education, it is by no means absolute to the exclusion or subordination of all other interests. This case involves the fundamental interest of parents, as contrasted with that of the state, to guide the religious future and education of their children. And it says, for instance, from a liberal pluralist point of view, I argue, there are multiple types of legitimate decision-making, and democracy is not trumps for all purposes. Another example, from a liberal pluralist point of view, public institutions must be cautious and restrained in their dealings with voluntary associations, and there is no presumption the state might intervene in such associations because they conduct their internal affairs in ways that diverge from general public principles. And then, I will conclude. It says, for instance, the relationship between voluntary association and publicly enforced civic norms has emerged as a key point of disagreement among contemporary liberals. Some argue that civic goods are important or fragile enough to warrant substantial state interference with civil associations. It is a mistake, they believe, to give anything like systematic deference to associational claims. I disagree. Galston disagrees. I begin with the intuition that free associations yield important human goods and that the state bears a burden of proof whenever it seeks to intervene. make counts of value pluralism, expressive liberty, and political pluralism, lend theoretical support to this intuition and help explain why we should not see state power as plenipotentiary. So, to synthesize, the position of Gelson is, in my opinion, interesting because it is completely different from the first two. That is, first two said, well, there are social goods and autonomy is the supreme good. Autonomy, free education, free thinking are the supreme goods for a person in order that for children, for pupils in school, in order that they can become mature adults and in order to participate in the public life. Gelson say no. In my opinion, it is not possible to make a degree of social good. For certain cases, autonomy can be important, but for other cases, to live in a community of religion can be important as well. And I don't think that the state has the right, the authority to say no. For me, state, the important thing is free education, and even if this to the cost of the life of the religious community. And this is another, an interesting position too. There are, of course, very many positions. I have passed my time, and I don't want to annoy you further. And well, synthetically, we have seen this. There is the U.S. Supreme Court decision for the free exercise of religion against, in a certain sense, against the conception that education is the first social good, the first good for children, for pupils. And there are different commentators, very many commentators. I only quoted 3 of them, but in truth, it is a huge debate because it is a debate what a person should be, what is the first value of a person. It is the first value of a person is her autonomy, his capacity to think freely, to mature their position in a free way, in an independent way, or not. This is the point. And of course, as the state does, the state have the duty to promote, to implement this autonomy or not. These are some of the questions. And well, of course, I am not telling you what I think. I have my opinion on whether there are social goods and whether there is a degree of social goods. And I am not going to tell you as well what I personally think of the decision of a U.S. Supreme Court. I have my opinion, but well, I don't want to influence you in the discussion because I don't want to take position yet. Still, if I am asked for, I will tell you what I think, but I think it is not so important. Important thing is to have clear what are the terms of the debate. Autonomy or not, school, what is the function of the school, and what is the function, and what last but not least, of course, do parents have the right to say, my children should do what I want that they do? Because this is another of the questions which are involved in this discussion. Thank you very much. Thank you.
Thank you very much, dear Gianluigi. So I listened to your report with great interest because I think that school education is directly related to how a person follows the norm of legal order. So it's very important for the jurisprudence and lawyers. And I have one question for you. As I understood, you said that communities there are a lot of communities whose culture does not support autonomy. So, for example, religious sects or immigrations communities. And it's a very distraction for, of course, school education and for children and for the new people and could you think about this problem in the government aspect? So could you believe in government? Can the government do anything for this group that they are in the society, so that they can live in our community, or this problem is impossible in the 21st century?
Yes, thank you very much for an interesting question. Well, so to speak, in order to give the answer that I think, I should say what I think about the debate. I do not agree with the US Supreme Court. No, I am not convinced by this decision, because I think that the Supreme Court has taken this decision at cost of the rights of the children. That is, Supreme Court has said, if there are 10 years compulsory school, then the children leave the community, and the community cannot perpetuate itself. This is my opinion, where the Supreme Court of 1972 made a mistake, because they sacrificed the right of the children to the right of the community. They forgot that the children can have a right to be educated, to be socialized, and to implement their knowledge. Also, even though this goes against the possibility that the community perpetuate itself in its values and its traditions. That is, what comes before? The rights of the individual, individual child, or the community. This is the point. Here we must take a decision. And personally, I think the right of the child to be formed in school, to acquire knowledge for life, to acquire that sort of sufficient knowledge in order to make his or her own opinion on the society, on history, on the tradition, is the supreme social good, the supreme school good. This is the first point of my opinion to which school should be oriented. In this case, since I personally think so, of course, I can be criticized, but as you think, there are persons who think that the US Supreme Court did have a right. Since I think that the first point is the capacity from the state to give the pupil, the child, the capacity and of course the instruments in order to become an adult who is independent, I think that the state should intervene towards the implementation of the rights of the child and towards the possibility that the child has the right instruction. Is translated public schools, of course, and a system of scholar education, which can be independent, which can implement the rights and the knowledge of the children. As regards the intervention of the state into the community, this is a difficult debate because, of course, you could say, if you are of the opinion that the child has a right also over and above its community, town community, the consequence should be, well, then the state should intervene also against the community, for instance, against the relatives, the parents of the children. This is a more difficult question because, of course, in this case, we should have always a kind of degree of prudence, The state cannot, in my opinion, should not intervene in too far a decisive way with far too much energy in the life of communities, in life of families. But I think on the other side that the state should have as aim to say, well, I want citizens which are mature for the public life. And this means public schools, state schools, and a system of instructions, and a compulsory school, of course, which can bring students and pupils, children, to the due maturity. It is of course, always a difficult question to say, to determine how much can then a state intervene in the sphere of the private space. This is, of course, a problem. As tendency, I would say the state should, in a certain sense, control and say clearly, well, my aim is to have formed adult citizens which are formed through a right civic education. That is at least my position. But of course, it is not the only one.
Thank you very much. If there are another questions for Dr. Segalebra. Okay, so thank you very much. Your report is very full and very excellent. I think that we should write about you in program much more, because dear Gianluigi Segalebra right now is working in a group cultural analysis in the University of Wien. So der Arbeitskreis für Kulturanalyse die Universität Wien, and I would like that everybody knows this information, so they put it also in program. And so, of course, Gianluigi interested in different topics of our society, of our culture. Thank you very much, Gianluigi. And of course, we're waiting for you on Friday, on our next day. So maybe you want to say something else, or we make another report.
I think that, thank you very much, of course, for your appreciation and for your interest and for your invitation. Well, I would say that the other subject, it is connected to this, because it is connected with the problem of multiculturalism, and of course also with the rights of the individuals and with possible rights of groups, but also with the compatibilities and with the incompatibilities which can be between rights of individuals and rights of groups. But well, we will see, I think, on Friday some application to all the debate of today, even though the question of Friday is lives from another perspective. But we will see that there are common points with today. We will see. Thank you.
Thank you, my dear moderator. Okay. So is everything okay with Ms. Ganjourova Polina?
Yes, I'm here.
Okay, thank you very much. And so I hope that our discussion right now should be very, very amusing, because our next presentation, it is about everybody. It is about us. So about problem of our methodological seminar, so law reenactions in the law and books. So next topic, it is methodology in law as a basic of law in action, living law of Olgan Ehrlich. So Ganjourova Polina, specialist of mediation, Institute of Conflict Resolution and Mediation, Kazakhstan. Please welcome.
Thank you very much. First of all, I would like to thank the Department of History of State and Law for your invitation. Ancient laws remain in force long after the people have the power to change them. And this said Aristotle. So, according to law philosophers, Western civilization reigned by law and reason has always differed profoundly from the savage world, guided by myth. Yet by making the creation of order out of house central to the concept of law, myth has lived on. From a Western perspective, the world of law and the world of myth have been considered two totally different worlds. Savages had a mythical worldview, and it was generally believed that through the use of reason, Western people had managed to civilize themselves and in the process had left this mythical worldview of the savage behind them. And this said Mr. Peter Fitzpatrick. He argues, however, that this is not the case at all by including the contrast between civilization and the in-civilized world of savages. In the concept of law, myth has continued to find expression. The creation of order out of house had always been a central theme in the mythical worldview. Although the rule of law originated in the Western world and included Western ideas about property and progress, it was considered to be a universal principle which applied to all human beings. Fitzpatrick states in this regard, law becomes generally and integrally associated with the mythic settling of the world, its adequate occupation and its bestowal on the rightful holders, the Occidental possessors and builders of the earth. But you know, here I have to say, I have to notice that this view of point, this is from American scientists more. So I will come now to you know, this is scientists from old Austro-Hungarian Empire, Julian Ehrlich, and on the contrary recognized two complementary sources of law. He made first legal history and jurisprudence. This is like precedents that seem useful along with their written explications. And second, this is living law as manifested in current social custom. Like normally it's coming, I will come later, I'm sorry. In the widely known foreword in which he synthesizes the meaning of sociology of law, Ehrlich makes clear his project to shift to the center of the concerns of the jurists of his time, what had become peripheral. So at the present as well as at any other time, the center of gravity of legal development lies not in legislation, nor in juristic science, nor in judicial decision, but in society itself. But still, in my opinion, and I cannot claim, but this is my opinion still, that not all center of gravity of legal development lies in society itself, and it is based on myths, because there is some consensus on the idea that normative facts are inserted into a social reality that contains many other non-legal phenomena. And about law in action. Law in action is law in change. A legal science aware of the relativity of its constructed object, but anxious to be closely linked to empirical data, supposes a study of these changes in norms. Thus, if one, by way of conclusion, combines these two perspectives and tries to think together the truths that they produce in their own right, one world arrives to the following legislative aporia: law is necessarily a part of society, as Ehrlich argued, as well as apart from society as Kelsen claimed. You know, this is different because this is a little bit from old Europe science. So as I said in the beginning, the American scientists and the old Europe scientists, same as to this legal system, they are different, so we can see a different view of points, or like, so in the conclusion, what can I say? I hope it wasn't so much difficult, so I made it easy for your understanding. And to youth friends, I tried so hard. And the music sounds. And one more time, I want to thank all of you. And for youth friends, I hope if they didn't understand, I can repeat it in Russian very short, if it's possible or not. Or okay. I can later and send by email to everyone.
Okay, dear Polina, I think that everybody understands because it's a very popular topic in our country, and I hope so, because all people, I think so, should think about themselves in the legal order. So you concentrate in the very great topic, dead and alive in law, and I think it's no problems to understand you, because it's about us. It's very we couldn't be indifferently in this item. Okay, then let me introduce myself, and because my presentation is the last, and of course I'm in this discussion of sociological approach, and I appreciate the opportunity to present my view on this point of view of jurisprudence, and I would like to present my report about the paradigm of justice, about the paradigm of Rudolf von Jhering. So another German school, because we can say that Eugen Ehrlich is German school, of course. So Eugen Ehrlich, it's more near with us, and Rudolf von Jhering, it's much more in the 19th century. And so my report, my presentation is the paradigm of justice, the struggle for law. It's very popular theory, but I would like to say about irrational in this theory. And I would like to make the main question that it's very important for us. And this question is, of course, a rational question. So first of all, I would like to say that Jhering is a very popular person in our country, and for example, there was the conference 2 months ago about Jhering. So a lot of presentations, but a few information about his point of view. It's a pity, of course. And so we would like to introduce maybe in the future our colleagues from Germany, because I know that in Germany Jhering is very popular, and a lot of books, a lot of articles are about his story, near or few information, but they're writing about him. So first of all, the recognition of individual freedom as the goal of the development of law, where the person's free activity contributes to the creation of new norms, is the merit of natural law theory. the recognition of the limitation of the freedom by specific historical conditions of the law of gradual development is the merit of history theory, and the recognition of law as a product of history rooted in human activity is the merit of Rudolf von Jhering. And about human activity, I would like to speak about. There are certain considerations that the ideas of dialectical philosophy, so we are I'm speaking about Hegel, so although Jhering said that it is not so, and he arrived at his views by studying the history of Roman law. So I said today about Roman law and of course about this region also. Some scientists, for example, French scientist Carbonnier, believed that concept of Jhering's struggle for law as it were copies from the formulation proposed by Darwin and Bismarck. So, for example, Darwin's formula struggle for survival and Bismarck's formula laws in the politics of power. But of course, Jhering is also original. He lived in that time, and he was the scientist of that epoch, and he knew these ideas, of course. The life of law is a struggle, he said, and legal norms are the result of the correlation of the struggle forces. The struggle for law. Jhering thinks that is that of the struggle, the best form is in the court, so in the form of lawsuit. And also he knew such forms of struggle as war, uprising, revolution, but he prefers court, so legal process. Jhering didn't intended to said that all law was created through this struggle. But in fact, there are customers and that are not so important, some norms that are not so important, and they are established purely, inconclusively, and spontaneously. But on the other hand, the most important norms are the outcome of struggle, and it's the main idea of his theory. So, with the thesis, Jhering proved that the importance of individual as opposed to exclusively state power, entire people or classes in the dynamic of law. And he defines the transformation of law as universal obligation in the continuous work. So he said, not only of everyone together, but of each person separately. And so the scientific possesses a philosophical problem. So this is the main problem, and I think that it is a rational problem, not rational, but irrational problem. So if any law is violated, is it fourth is to restore justice, or is it easier to come to terms with the suffered injustice? And every time, every person right now, when they are in bad situation, they thinks about it. So it's very, I think it's very great idea. It's very big question in our philosophy, in our civilization. So in both cases, the individual's behavior is associated with sacrifice. In one law, Jhering says, is sacrificed to the world. In the other, so the world to law. And Jhering takes the problem to a more global level. comparing the relation of private law with a similar issue of the international level, where everything is resolved and the people who would silently endure the violation of their law would be signing their own death warrant. The struggle for law is everyone's duty to themselves, so moral self-preservation and to society. He said, protection of one's own existence is highest law of the entire intimate world. And so Jering does not consider himself a defender of quarrels and disputes. The goal of law is peace, he said, but the means to achieve this goal is struggle, and struggle for the sake of avoiding the intrusion and lowliness. Jering said so that all the greatest gains of freedoms, the abolition of slavery and freedom of land ownership, crafts, faith, and etc., so were attained through blood and struggle. And it's very important because the law reigns in life. Life is a continuous movement and everything is constantly changing. Certain legal relations arise while other end and are destroyed. And I think when then the actual relations are reflected in legal relations, and the law is not a regime dogma. And every time a dogmatic jurist is forced to impose unsuitable prescriptions of the law on life requests him. So the most reason of all of this is so the slogan, so that we should fight for our right, and the struggle for law is our duty. If we want to change our life and to change our world, and it's our moral reason, of course, and so it's emotional side of our life. And for example, when our mind says to us, no, I am I'm not a fighter, so I'm afraid everything, then our heart, I think, should fight. And it's not only for theory for lawyers, it's a simple and clever theory for all people. And so because of that fact, I chose this theory for my life also. So thank you very much. So if there are some questions. So maybe my moderator has some question for me. Okay, so
yes, yeah. Well, yes, thank you very much for your exposition, your brilliant exposition. Well, there are very many aspects which are interesting. I should read something more in order to have also a better comprehension of the author. What I would like to ask, perhaps before of all, is a little bit like the question I put to Professor Geary. That is, there is in the author a debate about the existence of, so to speak, a body of ethics, of ethical principles, which are over and above the law, the positive law, or does it think that the positive law is all that we have? Because, well, I am interested in this position, and anyway, everywhere I have to do with a new author or with another whom I unfortunately not know very well. This question gives me the first orientation as his way of orienting his piece of research to. Thank you. This would be the first question I would like to pose.
I answer as I understood you, so excuse me. So I think the most important idea that the struggle for law is our protection. So protection of one's own existence is the highest law of our entire animate world. So it's our the most important duty, because we if we want to exist, and because when we cut out something of our rights today, then in future it will be it could be much more, and then another time. And for a human being is it's of course not a good, because then we should when we should say about tyranny, and without law a person descends to the level of an animal. So it's our moral duty. So like this. I hope to meet you all soon on December 4th, and right this time, so 12 by Moscow time, and till 14th of Moscow time, and see you soon. And please email me. I wrote in chat my email, and I would like to see all of you. Thank you very much. It was wonderful discussion. Have a good day, have a good time, and of course you should think about yourself, your health, and your life. So I hope that these ideas make your life better. Good luck.